Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit, are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 22-5305. S. Stanley Young, Doctor, and Louis Anthony Cox Jr., Doctor, appellants, versus Environmental Protection Agency, et al. Mr. Shoemate for the appellants, Mr. Busa for the appellees.
Mr. Shoemate, welcome.
Good morning, Your Honors. May it please the Court. Brett Shoemate on behalf of Drs. Young. This case involves an extreme example of an agency violating the fair balance requirement in the Federal Advisory Committee Act. 2 years ago, at the beginning of the current administration, EPA fired all 7 members of an advisory committee that had previously recommended against strengthening the national air quality standards. A few months later, EPA then selected new committee members, but they all share the same view. The air quality standards should be strengthened. And earlier this year, EPA proposed a new rule strengthening the air quality standards on the basis of the new committee's unanimous recommendation to do exactly that. This case is the flip side of Physicians for Social Responsibility versus Wheeler, which the court decided 3 years ago. In that case, EPA tried to exclude grant holders from serving on the committee. In this case, EPA stacked the committee with grant holders while excluding anyone who might share the industry's perspective that the air quality standards are adequate and should not be strengthened. EPA complied with the fair balance requirement in this case, then nothing would stop the next administration from doing the inverse of what EPA did here by firing the entire committee and establishing a new committee, stacking it with scientists paid by oil and gas companies, all of whom agree that the air quality standards should be relaxed, not strengthened. But before I get into our fair balance claim, I'd like to actually start with our APA claim, because everything that the government says in this case about fair balance is post hoc rational.
Could I just ask you to start briefly with a question about standing? And I know the government hasn't directly addressed your reliance on these equal protection cases, but and we'll hear from them. But one potential distinction, it seems to me, is that in those cases, it's very clear that the law provides an individual right to be considered free from discrimination, whether that's from the Constitution or a statute. And at least it's not immediately clear that FACA confers the same type of individual rights to be fairly considered. And I'm just wondering how you'd encourage us to think about that potential distinction.
My first response is the 10th Circuit has already addressed this question. Obviously, the court's not bound by that, but if you agreed with the government, there would be a direct conflict between this court and the 10th Circuit, the Colorado Environmental Coalition. But I think the theory of standing has been well established in Bakke and in this circuit in the Shea case, that whenever there's a denial of a fair opportunity because the government acts illegally, it doesn't matter what the illegality is, there's an Article 3 injury that a court can address. And so our theory of injury here is that our plaintiffs were denied a fair opportunity to compete for a seat on the committee because EPA violated the fair balance requirement. And they decided to give a preference to individuals who support stronger air quality standards. And if you set aside and require EPA to redo the selection and include someone who has an opposing viewpoint, it would create additional seats on the committee for one of our.
Basically, if they follow the law, your clients would have a better chance at getting on the committee, and that should be enough.
Correct. That should be enough. Yeah. There is no personal right to a seat on the committee. I acknowledge that, but that's not our argument. It's not, a university applicant doesn't have a personal right to admission at the university, but they still have standing to challenge an affirmative action program.
Thank you. I understand the argument, so please proceed as you were about to.
So the individuals, both of these plaintiffs, were competing. They were among the 100 candidates.
That's correct, Your Honor. They were one of the 100 that were nominated for a seat on the committee. Our theory of standing is that they did not have a fair opportunity to compete because the government gave a preference to individuals who supported.
The decision document put together by the staff and recommending who the EPA administrator should select said nothing about viewpoint.
That's correct, Your Honor. They
How do you know that, that your clients were not given a fair opportunity because of their viewpoint? And in fact, the small bios for the 100 people don't mention their viewpoint.
Your Honor, for purposes of standing, you have to assume that we're correct on the merits, that we've alleged a violation of the fair balance requirement, and assuming the truth of that allegation, then the government did violate the law and violated the fair balance requirement and had a preference for individuals with who supported stronger air quality standards. So on our allegation under the merits, which we have to assume to be true, they were denied a fair opportunity because the government violated the fair
I
balance.
don't know how you could possibly prove that in light of the Supreme Court decisions in the Morgan cases. Are you familiar with them?
I don't think I am, Your Honor.
Okay, there's 4 of them, and the ones that bear on this question are Morgan 2 and Morgan 4. And the Supreme Court held that you cannot, as a private litigant, explore the mental processes of the decision maker in an agency. So I don't know how you go about proving that the selection was such that it depended upon the viewpoint. You'd have to, look at the mental processes of the EPA administrator, which you can't do.
Your Honor, I do know of those Morgan cases, and I think those are APA review cases where, fair point, when you're reviewing the agency's decision on the merits, you don't evaluate the subjective intentions of the decision maker. But here, for purposes of our APA claim, we're not saying you need to evaluate their subjective mental processes or anything like that. Just review the agency's explanation. It is inadequate under the APA because the administrator did not provide a reasoned explanation of why he believes this committee is fairly balanced in terms of viewpoints. If you look at the staff decision memos, all they did was check the fair balance box. They never explained themselves. So we're not arguing here that you need to look into anything in the administrator's mind because he did provide an explanation. It's at page 21 of the joint appendix where he announced these individuals are going to serve on the committee. They have these qualifications, but he never addresses the one factor that Congress directed him to consider, which is fair balance. Neither did the staff. In fact, what's I think essential here is that, yes, in the decision memo, the underlying decision memos, the staff never even explained to the administrator why they believe the candidates that they recommended would establish a fairly balanced committee. Again, that's the one factor that Congress deemed relevant to establishing a new committee. It's fair balance. And the staff didn't even consider the GSA regulations or EPA's handbook, which provide factors and guidelines to consider when establishing a fairly balanced committee. So you don't need to look into the mental processes for purposes of our APA claim. You only need to look at the explanation in the record, which is woefully inadequate.
What if they're fairly balanced with respect to CO2 emissions, but not fairly balanced with respect to particulate control? This committee is the Clean Air Committee, which is responsible for all the pollutants across the board.
That's right, Your Honor. I think that would be a harder case for me, but I think here the facts are so extreme where we know the agency fired the previous committee, which in 2019 had recommended, again, strengthening the air quality standards for particulate matter, in part because the president on day one directed EPA to reconsider that particular rule that was promulgated in 2020. And the firing happened in March of 2021. And then in June of 2021, EPA established the new committee. It's mostly made up of grant holders who EPA would have known what their research is on air quality issues, particulate matter. I think it would be a harder case for me if the administrator...
There is a particulate matter committee too. Actually, there are 2 of them, right?
There is a particulate matter subcommittee that is formed out of this advisory committee, but there's not a separate...
The chairman of them has to be a member of the air quality or the Clean Air Committee. But what about the membership of the particulate matter committee?
That is not considered an advisory committee. So it's something that the chair of the committee can establish. I believe all members of the 7 members serve on the subcommittee, but they can expand it. So I think there were, a dozen or more individuals who served on the particulate matter review committee. Our plaintiffs were not selected as even.
This is by this committee is by statute.
Correct. The Clean Air Act requires EPA to establish this committee. I think what's essential about this committee and distinguishes it from many other advisory committees is that this committee has an essential role in the policy making and rulemaking process, because Congress charged this committee with recommending to the administrator changes to the air quality standards. That's in section 7409 D2B of the Clean Air Act.
Can I ask a question about your evidence and what your theory is on fair balance? So it seems to me that what you focused on is, as some of the questions have suggested, is views on the particulate matter standard. Not every standard the agency is going to apply. And it would seem a little bit odd to me if what we were telling EPA to do when they're filling a 7-member committee is basically to go through every issue this committee is going to work on and make sure you have somebody who currently has a different view on that issue. I don't really see how that's administrable. So am I misunderstanding the rule you'd have us adopt here?
Well, a couple responses. I don't think you are. I think the first response is it's incumbent on the administrator to explain himself. So that's our APA claim. The administrator didn't explain why he believes this committee would be fairly balanced. In terms of our fair balance claim, I think the way to assess fair balance starts with the GSA regulations, which say you look at the committee's mandate and you look at, does the committee have divergent points of view on the issues before the committee? And so this committee's mandate is to look at the air quality standards writ large and advise the administrator on whether they're adequate or not. So a policy judgment. So,
The proxy you want us to use for, is there an array of viewpoints on the matters to be studied, is for the agency to go out and find out what each individual person thinks. And maybe I'll sharpen this up a little bit, because throughout your briefs you say you needed somebody on the committee who had the viewpoint that stronger regulations on particulate matter were unnecessary. But they had that. They appointed Dr. Boylan, who said in December 2019 that he did not support strengthening those particular standards. And as I understand it, you come back and say, well, you didn't know how committed he was to that. And again, just goes back to the fundamental point. If we did this analysis the way you're asking the agency to do it, not only do they have to figure out in advance what everyone's going to think, but you got to make sure they're not going to change their mind. That was sort of my takeaway from your reply brief on this point.
So with respect to Dr. Boylan, I don't think you can count him as the person who would represent the industry's point of view that air quality standards are adequate for at least 2 reasons. Number one, he's a state regulator. He represents the viewpoint of regulators, which would be the public at large, consumers, and he supported stronger air quality standards in this round of review. So he was part of the unanimous recommendation. And in 2019, he just found flaws in the underlying risk assessment. He didn't come out and say, look, I would never support stronger air quality.
Yeah, that's what I want to understand. You're saying the problem is that you said, based on the current evidence, I don't support strengthening the air pollution standard, but I have an open mind. And instead, EPA had to find somebody without an open mind? Or is there another way to thread that needle?
EPA knew that there were opposing viewpoints on this particular issue. And the reason why I'm focusing on particulate matter is because that was the issue that was teed up for the EPA. Initially, it's the most apparent why there's a violation of the fair balance requirement. EPA knew exactly what it was doing in this round because it wanted a new recommendation from the committee that would support reconsidering the rule that had been adopted at the end of the prior administration. It knew there was an opposing viewpoint, at least with respect to particulate matter. We don't know if there were different views on the other air quality standards. And EPA likely knew, because it was funding the research of the academics that it appointed to the committee, that if it would appoint those individuals, it would get a different outcome. Yes, the administrator reappointed Dr. Boylan, but the statute requires a state official. He's the state official. He's a state regulator, and ultimately he supported strengthening the air quality standards. So if you look at full record, there was no opposing viewpoint on this particular issue.
Just one last question on the fair balance point. It does seem to me that a much more reasonable way to get industry viewpoint on a committee would be to have an industry representative. Then you wouldn't have to poll the audience on what they think about every single issue, which strikes me as a bit odd when you've got a scientific committee that's, their job is to study the issue and arrive at an opinion, right? And it seems you've conceded for very good reasons. This statute, when you read it in conjunction with 7409, doesn't require an industry representative. So I think my question is essentially, if Congress wanted to make sure one of these 7 members was an industry viewpoint, isn't the natural way they would have done that to have an industry representative?
No, Your Honor, I see my time is up. I'll answer your question. No, and our argument is not that there must be an industry seat on the committee. Our argument focuses on viewpoint balance, that there needs to be an opposing viewpoint. You can't have a one-sided echo chamber issue before the committee. And the reason why I'm focused on industry is because industry is the group that was championing opposition to stronger air quality standards. So even though this particular statute doesn't say you need to have an industry rep or an industry seat, but in addition to the other 3, EPA still has to comply with the fair balance requirement among the 7 selected for the committee. And they needed an opposing viewpoint. What they got was a committee that all supported stronger air quality standards, and that violates the fair balance.
In light of microbiological, do you think we are at liberty to hold that this is a non-justiciable question?
No, Your Honor, I think microbiological is controlling. I understand it's
on the jurisdiction justiciability question.
On reviewability, which is not jurisdictional in this court. But I understand that's a complicated issue, and there are persuasive opinions from Judge Edwards and Judge Silberman. I think the better case is Physicians for Social Responsibility. And the reason why is because that case established a binding holding in this court that the FACA regulations promulgated by GSA provide law to apply.
Was it focused on the point of view, fairly balanced inquiry, or did it go in a different direction?
It was not. It was, that was an ethics issue, and so the court looked to Part A of GSA's FACA regulations. Part B are the fair balance guidelines, which obviously are different than Part A. They establish different things, but the fact that there are GSA regulations that provide more detailed guidelines for an agency to follow when establishing a fairly balanced committee, that we put those out in page 75 of our appendix. That is the law that can be applied, and I think Physicians for Social Responsibility is obviously binding and makes clear that that is law that can be applied in a fair balance challenge like this one.
Can I ask you a question from the district court opinion in Physicians for Social Responsibility? Judge McFadden asks, suppose that the court could divine committee members' scientific and policy views and sought to balance membership between members who represent plaintiffs' views with members who represent opposing views. How would the court determine whether the views of a particular committee member are close enough to those of plaintiffs to find them representatives? And then he quotes Judge Silberman. Would the court rule, for instance, that when 2 parties agree on a certain percentage, what percentage, of issues, which issues, one may be deemed representative of the other?
I think those are very persuasive points. I think Judge Silberman is persuasive. However, obviously Judge McFadden got reversed on that issue in Physicians for Social Responsibility on the reviewability point.
On whether the ethics was reviewable, but not whether the question before us is reviewable.
That's right. But I think the GSA regulations provide the missing link that Judge Silberman was looking for in microbiological and that Judge McFadden was referring to, which is Judge Silberman's complaint was, how am I supposed to decide what are the relevant points of view? It could be infinite, right? But he also said, if somebody could narrow for me it down to 2 or 3 relevant points of view, that might be a different case and he might find it reviewable. GSA regulations, which were promulgated in 2001 after microbiological, again, they're on page 75 of my brief, they talk about several factors that an agency must consider in establishing a fairly balanced committee. You start with the mission of the committee, and then you look to the types of perspectives required. For example, those of consumers, technical experts, public at large, academia, business, or other sectors. And then I think this is the key one. the need to obtain divergent points of view on the issues before the advisory. Here, the issues before ASAC were whether the air quality standards are adequate or whether they should be changed. There are two opposing viewpoints on that issue. You know that from the 2019 recommendation that said they're adequate.
There's only two?
There's at least two.
I mean, there might be infinite.
There might be infinite, but that's why
And I
they're,
mean, just take one of the words that you mentioned, consumer viewpoint. I mean, the three of us are consumers. I don't know if we agree on everything. Right?
and that was Judge Silverman's point in.
Why is that wrong?
Well, I think the GSA regulations constrain the agency's discretion quite a bit and point the agency to what to look at by clarifying what points of view are relevant. It's not all the many issues that might come before the committee. It is, what are the issues before the committee according to the mandate? And we know what the mandate is here. It's clear in section 7409 in the charter on page 7 of the joint appendix makes clear. It's about policy. Should the rules be strengthened? And maybe there are more than two, but the GSA regulations identify the types of perspectives the agency should look at to see, well, whether they have different points of view. But on any rulemaking issue, there are typically going to be two different camps. Should the rules be stronger or should they not be strong? And in this case, I think
There's a status quo. Should we keep the status quo? Should we increase regulations by a little? Should we increase them by a lot? Should we decrease them by a little? Should we decrease them by a lot? And then there's a spectrum from one extreme to the other that probably has, again, an infinite number of possible positions.
that may be true, but there's really a binary question at the beginning, which is, are the rules adequate? And there was unanimity on this committee that the rules are not adequate. Now, after you cross that threshold, yes, the standard could be raised to an infinite number of levels, but there was an exclusion of the opposing viewpoint that the current rules are adequate. And so, at a minimum, in extreme cases, the fair balance standard provides law to apply, and this is an extreme.
Let me ask one kind of in the weeds question and then one big picture question. Do you know if the defendants in microbiological at the district court filed a 12B1 or a 12B6 motion? Were they arguing merits or were they arguing?
That I don't know. But
All right.
I think what you're
it's not
getting
on
at
pacer.
is whether reviewability is jurisdictional.
I'm trying to figure out what the district court did there. Did the district court say this is non-reviewable, which the last paragraph in microbiological suggests, or did the district court say I'm dismissing on because this is fairly balanced, and then the appellate court did what we did?
I don't know. I know that
Okay.
the circuit opinions we're talking about justiciability.
Yeah, and then kind of taking one step back, this, fair balancing requirement that Congress has imposed, do you think that it's constitutional in the first place for Congress to tell the president who he's allowed to get advice from, who he has to get advice from?
It's a great question. I don't know the answer to that. It's obviously not brief. I don't know, Your Honor. I mean, typically, the president can get advice from whoever he wants. That is, and Congress can't constrain his ability to remove
That's
federal
what he did here, and you seem to object to it.
president.
The administration said we want advice from these people, put them on the advisory committee, and you say, no, that's illegal.
Congress enacted a statute to constrain the administrator's discretion and Congress's discretion, not the president's.
The administrator works for the president.
He does. And we're not complaining about the administrator's firing in March of 2021. We've raised no claim to challenge the firing. We're just challenging the composition of the new committee. So I don't think this case presents that constitutional question where there's not a restriction on the president's removal power in this case. This is a case about compliance with a statutory requirement to ensure good scientific advice is provided to the agency. And in this case, the agency rigged the science to get the result they wanted because the president wanted to change the rule.
Anything else? You look like you
With
have another
apologies, one more question, because just of many things that are difficult about this statute, in this discussion, I think we've assumed that points of view represented means the views of individuals on specific issues to be studied. And I'm just wondering, how do we know that? Couldn't it also mean points of view in terms of their expertise? for even who they're affiliated with. It says points of view represented, after all. So maybe it means you think about, is there someone from an environmental group and from industry? How do we know that we should read it the way you want us to read it?
I think it's a great question, and I have two responses. And I think this is mainly the government's point and the district court's point. But the two responses are, one, the statute is disjunct, says functional balance and viewpoint balance.
Well, then you got to tell me what functional means.
I'm happy to. So function means, do we have the right type of people with the right qualifications to perform the work of the committee? And so this committee, putting lawyers and novelists on this committee probably wouldn't be a functionally balanced committee, because I'm not qualified to do the work of the committee, but scientists and different types of experts are. So that's what functional balance is trying to accomplish. Viewpoint balance is trying to accomplish, well, what are their points of view? And I think, again, the GSA regulations are very helpful in describing at least what GSA thinks viewpoint balance means. It's divergent points of view on the issues before the committee. So that's talking about what are their, how do they approach the issue? What are their opinions? And here we know what the different points of view are, because EPA tried to exclude the.
Thank you.
Thank you.
Good morning, and may it please the court. Joseph Busa on behalf of the government. The standard I heard my friend on the other side offer in response to this court's questions this morning is unworkable, contrary to the statute, and we should win on the merits under any applicable standard. I just want to start by clearing up some misconceptions about who's on the committee and what the committee has done so far. Dr. Boylan has dissented on 6 different standards that have been reviewed so far. Now, I can list them off. That's the PM 2.5 primary 24-hour standard, the PM 2.5 secondary 24-hour standard, the sulfur oxide secondary standards, the nitrogen oxide secondary standards, the ozone primary standards, and the ozone secondary standards. And that's just so far. And that's entirely predictable. If someone were trying to figure out what is Dr. Boylan going to do on the committee, what does he think in general on these issues in 2021 when the EPA administrator was appointing this committee, the best data point was his most recent vote not to further tighten the PM standards. So just to begin with, even on their standard, we should win. But I want to highlight how extraordinary it would be to require the EPA administrator, when making these personnel decisions about a scientific advisory committee, to somehow make a predictive judgment about what all 100 candidates would do if they were faced with all 17 ambient air quality standards, and then try to assemble a group of 7 people that maximally disagree with each other on all of those issues. That's nearly an impossible task, and it's one that's antithetical to the statute. This is a scientific advisory committee. The whole point of the committee is to review evolving science, discuss the topics with each other, bring to bear their individual points of view. And I'm sorry, so you have a question?
I don't quite understand the distinction between, in this context, an EPA scientific committee and an EPA policy committee. They're making policy recommendations, right?
I have to disagree with you on that, Your Honor. The statute says that you set ambient air quality standards at the level that is requisite to protect public health or the public welfare.
It's guidance on what the policy should be, and then they make recommendations on what the policy should be. I'm not saying that the policy is just picked from thin air without any consideration of science, but I mean, the EPA is a policy making.
Your Honor, with respect, they're recommending
regulation making administration.
So the question would be something like, look, is a level of 8 micrograms per square meter over a 24-hour period the level that is requisite to protect public health? Or are there adverse effects on the human body that kick in earlier than that we need to know about? That's the work of the committee. I mean, if you review...
Yeah, it sounds like a policy question. Should the policy be 8 micro, whatever? But you started out by saying it would just be extraordinary to do this, and I'm sympathetic to that, but I mean, maybe it's an extraordinary statute. It strikes me as a pretty extraordinary statute.
No, so with respect, the statute here requires scientific perspectives. It's an independent scientific advisory committee that tells you the perspectives you're looking for are scientific perspectives, not ultimate conclusions on all 17 ambient air quality standards. The work of this committee...
If it was all science and this is nothing to do with policy. Why did the administration make the major change to the committee that it made?
Oh, so the administrator explained this. It's in the record. We explained it in our brief. The committee that this administrator faced when coming into office was chosen under very unusual circumstances, under a brand new policy that had never been applied in the APA's
Grant,
history, and the grant recipient issue.
Did it
Policy that was later enjoined and then received. I'm sorry, Your Honor.
Did it think that that committee was full of bad scientists?
No. So
Then why did it need to change it?
also
I get that
because
it didn't like the method by which they were selected, but if it's just a scientific committee and they weren't bad scientists, then why not keep them?
there is nothing unusual about an agency head coming into office and saying, I want to apply our traditional standards that we've always applied, not the standards that were recently enjoined by the Southern District of New York. There's nothing unusual about that at all. And then if you just look at the process that they ran, it is by the book and ensures a fair balance of all the scientific perspectives needed. So they say, thank you for your service, please reapply, because we need different scientific perspectives. They assemble a group of 100 candidates, evaluate them on the basis of their scientific expertise. They say in their solicitation for nominations, we need the following perspectives to be fairly balanced. And they list all of those scientific perspectives. What they don't need at that early stage in the process is we need people who are willing to raise their hand right now and say, before reviewing any of the evolving scientific evidence, the package that this committee actually reviews when it does its own work, before doing any of that work, we need you to pre-commit to, what you think should happen with every single one of the standards.
I think I asked Mr. Shoemate this as well, but what do you think is the binding holding coming out of microbiological with regard to the justiciability question?
There is none. I think that's pretty clear. I mean, so you
Why do you
have
say that?
Judge Edwards in dissent reaching the justiciability question. You have Judge Silberman concurring, reaching the issue, but they both disagree with each other. No holding there. Judge Friedman doesn't address the issue.
Well,
It is
I don't think he addresses it expressly, but he says this committee is fairly balanced, which seems like you can't say it is fairly balanced unless the question of whether it's fairly balanced is a question that can be answered.
So I disagree. I think I have two lines of response, Your Honor. The first is just, it is beyond clear that when a court reaches a decision on the merits without addressing a threshold issue, that does not stand for a holding that the threshold issue that was not raised is like precluded as a matter of precedent. This is just an application of that principle. Secondly, every human being can have their own view of what they would do with a fair balancing requirement if they were going to appoint a committee. And yes, you can ask everyone on the planet to try to figure that out with respect to any given committee. But that's not the question Heckler asks.
And I think I'm probably on board, but imagine that I think Judge Friedman's opinion is best read to say it is justiciable. Judge Silberman's is, of course, read to say that it's not. They were the only two, I think, who joined the judgment in full. I think that means we don't consider Judge Edwards' dissent because you don't consider the views of a dissent from the judgment when you're trying to figure out the holding of the court. Do you agree with that, or do you think I'm kind of doing fractured opinion analysis wrong?
I wouldn't want to give you an off-the-cuff response to that, Your Honor. It's a bigger question going beyond just this case.
I haven't figured it out entirely.
But I think I would think of it in this way. Judge Edwards says the reason this is not an open question in our circuit is because of national anti-hunger, where this court resolved a fair balancing claim on the merits. Now, he's wrong about that. You can just read national anti-hunger, and you know for a certainty those judges did not decide anything about justiciability. In that respect, Judge Friedman's opinion is identical to the majority opinion in national anti-hunger. They're relying on microbiological, but they're wrong if they're also wrong if, like, national anti-hunger didn't already establish this, 10 years earlier. Now, so on justiciability, sorry.
Let me ask a question about putting microbiological to the side. The question, as I understand it, is whether there are even administrable standards in extreme cases. So let me offer you a hypothetical that I view as pretty extreme.
I love hypothetical.
But, so just imagine there's an EPA committee that is policy-focused. And it's got 20 members, and you have people with all types of different expertise, but they are all from the Sierra Club. And they do similar work to what this committee does. Why can't a court step in and say, look, points of view represented, if it means something, it has to mean at least you have to have some representation from the different types of affected entities. And in this very extreme case, we're going to order you to redo this. So there's, at least in some sense, there are different points of view represented and not just functional balance. Would you concede that that is something a court could do?
I guess I'd need to know more about the specific work of the policy committee and whether, you've identified a degree of uniformity on one axis of membership of that committee, but is that necessarily relevant to the policy, the work of the committee? I don't know. I need to know more. This just goes to the point that there are nearly infinite perspectives one could take with regards to every policy issue under the sun. These are advisory committees whose sole point is to help the administrator reach a good decision, is to help the administrator in accomplishing his or her tasks. That person is best positioned to figure out what policies, sort of what their vision is, what kind of advice they need, and therefore taking together lots of trade-offs, the court's not really qualified to consider, what the composition is going to look like. And so, for example, in your hypo, it's going to depend on what the applicant pool looked like and any number of other issues.
And I do think it would be very odd for a court to ever mandate the composition. But I do think a court can say, when you have no plausible story at all about how there's a relevant diversity of points of view represented, you need to go reconstitute your committee. And it's not entirely, this is LDF versus Barr is this hypothetical on one view, Judge Bates' opinion there. And so these things do happen, and I don't see why a court can't step in just those extreme cases.
Again, I think that the types of perspectives that are going to best help the agency are for the agency to consider in the first instance. Congress reserved to itself the primary role in enforcing FACA compliance and saying, hey, we're going to make a continuing review of all of this. Congress did not supply any judicially manageable standards for the fair balance requirement. And finally, the EPA is trying to withstand judicial review of the final rule that it issues. This is not the end of the line here. The EPA desperately needs good advice so that it can withstand the gauntlet of judicial review that always follows from the promulgation of the final air quality standard. So, I mean, we've addressed.
Do you think NAACP was correctly decided by the district court?
I'm sorry, Your Honor. As I stand here, I'm just
It's the one,
losing
everybody on the
this.
committee was a police officer, I think, or from the police community. And the district court said, well, that's not fairly balanced, because I guess all cops think the same. I don't quite, I don't think it was correctly, do you think it was correctly decided? Based on those facts, does that sound like?
So as I understand it, there was some sort of committee. They were all cops.
This
And someone said you can't have
I
all
think is
cops.
strong. It's harder for you, but.
I wouldn't take I just think it's hard to say, look, anyone who's ever had that kind of a job, they all think alike. I mean, you all have the same job. You all think very differently from each other. The same is true for me and my colleagues. People have wildly divergent ultimate conclusions, sort of regardless of their institutional affiliations very frequently. So yes, we do think that these cases just aren't justiciable, but we're not asking you to make huge law here. We should win under any applicable standard in this case. And again, that just goes back to Dr. Boyland, Dr. Chow, the actual committee members in this case. Dr. Boyland, who routinely dissents from so far 6 different analyses on 6 different ambient air quality standards.
Just because you didn't have an opportunity in the briefing, do you have a response to the standing theory that was offered in the reply brief?
Yes, I do, Your Honor. So the theory they're relying on now is equal footing. They say they need to be considered on an equal footing with every other applicant. Well, that's exactly what happened here. I mean, the record is replete with evidence. This is pages 42, 250, 263, and 321 of the joint appendix, that all 100 applicants were evaluated according to the exact same metrics, and selections were made on the basis of the need to have a 7-person committee, fully staffed with all of the scientific perspectives needed to do a very big job in, a broad range of factual areas. Those are the metrics under which they were evaluated. This is not like Bakke, where the allegation, where the facts are, some types of people get evaluated under one yardstick and some types of people get a different yardstick. It's just not like that case. And therefore, it's not like the Colorado case.
So let me ask you this because you're certainly right, it's not a direct analogy, but it's similar in the following respect, where the fundamental claim is if you followed the law, I would have had X% greater chance of being selected. And their theory here is basically you needed someone like me on the committee. FACA demands a set aside for someone like me. You didn't realize that. But if you ran this process again, I would obviously have a better chance at securing this government benefit.
But with respect, I'm not sure they're making an identity-based claim. They're not saying you need someone like me.
Someone with this viewpoint. I'm trying to simplify it.
Right. So there, it's just like we used the exact same yardstick with respect to every applicant. This is just not like Baki, and crucially, there's no expectation of an appointment to any advisory committee. The statute and the GSA regs make perfectly clear it is wholly within the discretion of the appointing official.
Not like Baki, but is it like the Harvard College case?
I guess I'm not immediately thinking of a distinction. I mean, they're both affirmative action cases where the allegation is there's a
Let's
different
suppose
yardstick.
there was clear evidence that the administrator chose half of the committee on the basis of race.
Oh, we concede that would be just like Baki.
That would
and
be
there could be.
unconstitutional, right?
We're not, no one's raised a constitutional claim here. We're not getting into that. I'm just saying there would be standing if there were the allegation where there's just different yardsticks or if the evidence.
If a university can't give a bump to somebody because of their race, which is what Harvard College holds, then why should the administrator of EPA be able to do that?
Oh, we're not saying that happened here, and we're making
Well,
no argument.
you know, in the selection document, at least 3 or maybe more of the people were identified as by their race, as if that were a credential.
So, Your Honor, I take those to be sort of by the way notations, but not a decisional criteria in those documents. I think that's clear from page 42 of the joint appendix, where the staff recommendation says we evaluated the 100 candidates on demonstrated competence, knowledge, and expertise in scientific and technical fields of air pollution and air quality issues, and that this committee is thus balanced. That's page 42. Then the basis for recommendation, the basis for the staff's recommendation is listed. You see an example of this at page 48 of the joint appendix. Those are the grids where the staff goes through and analyzes the basis for the recommendation for each of the people who are being recommended. None of the material inside of that basis for recommendation grid lists anything about sex or race. So it is not unusual for a decision maker.
How did the staff know the race of the individual applicants?
I guess I don't have information for you on that, Your Honor.
Or what?
I don't have information for you on that, Your Honor. I don't know. It's not reflected.
Okay.
If there are no further.
If someone thinks EPA here considered race and gender based on the bullet points in the decision memo, do you have any argument that that does not render the selection process arbitrary and capricious? I think you might have suggested they could have brought a different type of constitutional claim or something like that.
I'm not suggesting
if they thought that that was what the evidence showed. But do you have an argument that it is permissible to consider demographic factors like that?
We haven't
in the
raised that
context of
argument
an
here, and we're not asking you to decide that. Our sole argument on that point is that did not happen. It was not a decisional criteria. Again, if I could just go through, exactly why we think that is. There's the whole process for selecting these folks. It was very clear that the criteria are going to be what kind of scientific expertise do you bring to the committee. You see that from the email about the reconstitution of the committee, where they say we're seeking nominations of experts in a variety of disciplines. You see that in the Federal Register listing, where they say the disciplines they're looking for in order to have a balance of perspectives. You see that in the EPA staff evaluation of the candidates, quote, based on demonstrated competence, knowledge, and expertise in the scientific areas. You see that in the Brennan Declaration. This is the agency official who's in charge of all of this, explaining further, we evaluate these people on the basis of their scientific disciplines. And then, look, basically what they have is a press release saying, by the way, we're pretty proud of the diverse, of the gender and ethnic diversity, the folks we have chosen, but presidents of both parties have been proud of the diversity of the candidates they have chosen going back for decades. That cannot, yield a legal problem in the selection process.
Thank you very much.
Thank you.
You are out of time, but we'll do 2 minutes.
Thank you. 3 quick points if I have enough time. First, on standing, the 10th Circuit has squarely addressed an individual's standing to challenge a non-selection for violating fairly balanced requirement under FOC. So you agree, the government, that we don't have standing will create a direct conflict with the 10th Circuit. I just want to emphasize, for purposes of our standing, the court assumes the truth of the merits of our merits claim. So you have to assume the truth that there was a violation of the fair balance requirement. And under our theory of the case, had the government not violated that requirement, it would have been easier for our plaintiffs to be selected for the committee. And if you require them to redo the selection, they would have a better chance of being selected on the second round if EPA were establishing a fairly balanced panel. Second, on reviewability, neither Judge Silverman or I think Judge McFadden had the benefit of the Supreme Court's ruling in Department of Commerce, which clarified that Section 701 is an extremely narrow exception to reviewability, really confined to areas that are traditionally committed to agency discretion. And the court in that case found a very broad delegation of authority to the Secretary of Commerce to conduct the census was enough to provide law to apply here. You not only have standard in the statute, you have mandatory directive, shall, and you also have the benefit of the GSA regulations that fill in any gaps with respect to what fair balance might mean.
What's the overlap, if any, between that APA provision and just general Article 3 political question non-justiciability inquiries?
I think those are separate considerations. Congress in Section 701 created 2 exceptions to reviewability. We're only talking about the second one here about matters that are committed to agency discretion. The Supreme Court has said that's areas like prosecutorial discretion or where there's really no law to apply. It all collapses into the question of whether there's law to apply either way. Physicians for Social Responsibility kind of makes that clear. And again, if the court previously relied on subpart A of the GSA regulations for law to apply, this court can also rely on subpart B. And if you disagree with us on reviewability and agree with the government, this would be a direct conflict with the 5th and the 10th circuits on reviewability. Finally, just to wrap up, our APA claim.
Very briefly, please.
Our APA claim is probably the easiest way to resolve this case because there is no contemporaneous explanation in the record for why this committee is fairly balanced.
Thank you very much.
Thank you.
Case number 22-1204 et al. Thrifty, Payless, Inc., doing business as Rite Aid petitioner versus National Labor Relations Board. Mr. Silvestri for the petitioner, Ms. Beard for the respondent.
Good morning.
May it please the court. Good morning. My name is Stephen Silvestri. I'm here for Thrifty Payless, which I'm going to refer to as Rite Aid because that's their current corporate name. With me on the brief and here at council table is my colleague, Alana Glover. So I've reserved 2 minutes for rebuttal. There are 3 reasons we're urging for denial of enforcement of the NLRB decision here. One is that it applied an impractical and inappropriate standard determining there was no exigent circumstances that allowed Rite Aid to move coverage of medical insurance from a co-sponsored health plan to Rite Aid's plan. The second is that the ALJ and the board ignored inappropriate and refused to consider uncontradicted record evidence that there was impasse at the time we moved it. And the third is that the NLRB, not the judge, but the NLRB inappropriately ordered Rite Aid to make payments of all of its contributions as a remedy, where that remedy wasn't requested in the complaint. No evidence was taken. The GC, the general counsel of the board, never introduced any evidence about that in trial. There was just a lack of due process in connection with that. There are important facts in the record that I want to point out first. One is that the bargaining unit here had 3,000 associates, and the number of covered lives were more than 10,000 in this plan. This wasn't a plan of a few hundred employees. There were many, many covered lives here. So the second is that the Rite Aid and the union had a long history of collective bargaining. This is not something that's new. It's not something that Rite Aid or the union approached with unprofessional negotiators or inexperienced counsel. The annual contributions of Rite Aid, third point is, the collective bargaining, through the collective bargaining agreement, were like per hour rate for as many hours as the employees work. They were over $20 million a year to cover these associates in this plan. So the exigency standard in this court is that the employer must show the exigency was caused by external events, was beyond its control, or was not reasonably foreseeable.
Mr. Silvestri, can I ask you about your remedy argument?
Yes.
I'm not sure. Are you saying that there was an alteration by the board compared to the remedy by the ALJ?
Yes.
I know you're saying that. Are you saying that that alteration created a windfall?
Yes. It definitely could create a windfall, because obviously when Rite Aid switched the coverage of the plan from the union, from the Valley Employers Trust Fund to the Rite Aid plan, it continued to pay exactly those amounts for benefits.
It sounds like what you're challenging in terms of remedy is the alteration, not what came before the alteration.
Right. It's the alteration of having to pay without taking any credit for the amounts that Rite Aids have already put in.
And the government says you can make your argument at the compliance proceedings.
That's true, as long as the compliance judge doesn't accept as fact that remedy.
Doesn't accept what?
As fact, the remedy that's ordered by the board. If the compliance judge is saying, okay, now I'm willing to hear evidence and make findings with respect to the amounts you paid and whether there are any gaps in that.
But I think the government says, and I'll confirm with the government, but I think the government says that in the compliance proceedings, they can do that regardless of what we do here.
Well, maybe.
With regard to remedy, regardless of what we do here with regard to, do you agree with that?
No, I would simply suggest that you have the power to order that.
Okay, I know that, but
Right. And
let's say that we don't, and then you argue in the compliance proceedings your windfall argument.
right.
The government says the compliance, proceeding resolution might agree with you, and you might get what you want. Do you agree with that?
If the government is willing to concede that we have a right to make that claim and a right to have a judgment based on that claim and reviewed by the NLRB and ultimately reviewed by this court or some other U.S. Court of Appeals, yeah, then I agree. Okay.
I'll ask
But it wasn't clear in the government's brief that I read that was the case.
Okay.
All right. So the board, in this case, adopted without change the LJ's findings and conclusions of the law. And I want to point out one particular aspect of that finding on the exigency standard that I think is glaring. So at Joint Appendix 15, the judge, the LJ, makes the following conclusion. Health plans, by their very nature, and I'm quoting, are full of uncertainty. It is impossible to predict what claims may have come in, how would impact the reserves. Such predictions are left to the benefits experts. But wait a minute. Doing that, the judge and the board swept aside every single piece of evidence that was put in this case, every single actuary's report. There was an expert that testified. The GC called her to testify. And the expert said in September of 2019, weeks before this impasse was declared, that there were 0.07 weeks
So the-
of
the
reserves
funds-
left.
The funds increased to 1.6 million in December, and I just wasn't sure why. Do you know why?
No, it could be a change of revenue versus expenses.
Well, presumably.
Right, but,
Do you know why?
as of December, the fund experts reported that there was less than 2 months of reserves remaining.
But I went from 1.2 to 1.6 million, and I completely agree with you. Of course, it has to do with revenues versus expenses. So,
right.
do you know if revenues went up? Did expenses go down?
Well, revenues change from month to month depending upon how many hours are worked, how many employees are covered. So they vary. And obviously, expenses change from month to month. So
Yeah,
one of the
but
things.
I get, and maybe the answer is you just don't know. But do you know, like, why?
No, there is unanimity in the record that as of December of 2019 and the months before that, the fund was in fiscal crisis.
That's not my question, but okay. You can
Okay, but-
proceed.
Yeah, all right. So
Can I just ask, when you make those statements, are you relying on Ms. Lang?
I am.
and her statements in the record?
I am, Judge. Yeah.
Okay, so
Not
on,
only your statements in the record, but also the actual reports of the actuary month to month or quarter to quarter that are in the record.
right.
Right.
Yeah, and so what she says, for example, is in November, there's $1.2 million left in reserves. And what you portray that as is this fund is 3 weeks from collapse.
That's
But
what
that's not really what it means, right? That's if you entirely stopped bringing in money.
right. What it means,
Yeah.
you're right. It doesn't mean it's 3 weeks from collapse. It means that it's an inappropriate standard for running a healthcare fund with thousands of participants. So this fund also had a relatively low, surprisingly low stop loss floor, $150,000. So anything below 150 was coming out of the fund's wallet. Everything above 150 is coming out of the reinsurance wallet. And there's quotes from Ms. Lang and from the union's chief negotiator that any number of claims at $100,000 or $100,000 will make this fund run out of money. That's in the fall of 2019 in the record. So again, it's not necessarily a question of whether the employer had notice of the circumstances. Everybody had notice. In these kind of cases where there is experienced counsel and experienced experts involved in negotiations, you always have notice that the fund's going to run out of money. They had notice since 2018. And gradually, those reserves got lower and lower.
Now, I just have one more specific question. So I understand you're relying on Ms. Lang. My understanding, or at least the board found, that on December 5th, Ms. Lang supported the union proposal and then later testified that it would have continued to increase the reserves. What's your response to that?
The response is that disagrees with the union's chief counsel that says we're ignoring reserves in our proposal. And I'll say that in the record, the union proposed in December 5th an increase of the contributions to $5.02, I think it was, where the union and Rite Aid, as a potential measure for trying to see if it could affect the funds, in 3 months, July, August, September of 2019, Rite Aid was contributing at $5.72, and that had very little effect on the reserves. So the union was proposing in the end a reduction in that, which we know would have not worked. And they were also proposing, just to be fair to them, they were also proposing that employees pay, because the employees weren't paying anything.
What would
But-
have happened?
Right.
You finish
I'm
the
sorry,
sentence.
no, all right. So,
Finish your
so,
sentence.
but that proposal that the union was making wouldn't kick in for 12 months after the first of the year.
What would have happened if you had waited until the fund ran out and then switched the employees from the union fund to the company fund?
So the employees would have lost benefits because the payments are in arrears. So if the fund runs out of cash, I'm pregnant or I got my arm broken, I'm going to the accident room, I put my medical card in, the administrative person calls the fund says, I don't have funds, you don't get service. So what would have happened is the union would have insisted, again, this is not in the record, but this is just collective bargaining. The union would have said, blank check, you guys pay for it. You're the only employer in the fund, so issue a blank check. That's what we were facing. So a blank check is not what's in the collective bargaining agreement. What's in the collective bargaining agreement is X dollars a month per person.
Thank you, Mr. Silvestri.
Thank you.
we'll give you.
I have one question for you.
Yes, Judge.
What is the difference in the cost to the employer of having the health plan in the employer's fund as opposed to continuing with the union fund?
Substantial. So the employer's
is what?
fund, substantial. And I don't have the actual number of what it would have saved, because the parties weren't focusing on that savings. The parties were focusing on the delivery of benefits to the employees. The reason why I say substantial is because that fund covered many more thousands of lives than the Valley Employers Fund. That fund covered all the rest of Rite Aid's employees across the United States. So not tens of thousands of employees, a lot more employees to spread the risk over in terms of the fund. That's why it would be cheaper.
Understand. Thank you.
Thank you.
Thank you. We'll give you a minute on rebuttal.
Thanks.
Morning, Heather Beard for the substantial evidence on the record here demonstrated that the company failed to prove that they were at an impasse when they implemented their new collective bargaining agreement, including the new.
Can you drop those microphones down a little bit? I think we'll hear you more clearly.
Is this better? Yeah. Okay. So I'd like to address first the issue of impasse, unless Judge Walker, I could go right to the remedy. It sounded like you had questions.
I'll wait.
Okay. So with regard to impasse, the board applied its well-established factors in looking at all of the evidence to determine that the company didn't establish the parties were at impasse on December 5th. Now, Judge Randolph's question to my friend on the other side was a good question about the cost of the new Rite Aid plan that the company was going to go into. That was something that, despite the union asking over and over what that cost would be, that was not revealed until 2 days before the final bargaining session, when the union was able to move very significantly towards keeping, as Rite Aid said it had wanted, trying to keep it cost neutral. That is one of the factors, one of the important factors under Taft, which is the parties' contemporaneous understanding. And at the end of the day on December 5th, the union had just received, few days earlier, information as to how much more would the healthcare plan cost. And Rite Aid said it was willing to spend either $1.2 or $1.4 million a year in the Rite Aid plan. And so what the union did, with the support of Ms. Lang, who came and testified and who supported what the union did, is move as close as their understanding was to Rite Aid once they had the information, so that they could do what Rite Aid said throughout the duration of the negotiations, which is, we don't care whose name is on the healthcare plan. What we care about is actually covering these employees and getting a new collective bargaining agreement. We agree, it's very significant how many people are covered by this. And this new Rite Aid plan did have employees who lost healthcare coverage. So we're not, this is not who's bad, who's good here. This is, under the board's standards, were the parties at an impasse, which was the burden on the company. So we've got that factor, number one, alone sufficient, contemporaneous understanding. And the board went through, the board also found that the company negotiated in bad faith here. They found that the importance of the issue and the history of the parties, again, I agree with my friend on the other side, this counts in favor of the fact that the company failed to demonstrate an impasse. There was a long bargaining history here. And so the Taft factors are impasse. Now let's talk about economic exigency, if you will. The standard for economic exigency is whether there is a compelling reason to immediately implement something. There was not a compelling reason to immediately implement. Now, it is true that the reserves in the fund, which the company continuously said they wanted to build them up so that they had 3 months. Okay, this was also part of the bad faith finding that my friend does not mention, which is that until the hearing, the company didn't tell the union that it was looking at 6 months that it wanted these reserves there. But what Ms. Lang also said is that regardless of the reserves in the fund, a healthcare fund doesn't collapse if the reserves are low. It depends on the amount of contributions and the amount of expenses. And from the record, what was happening with this fund, as had happened for years, in fact, the fund had gotten low in 2013 and 2014, I believe, to 2.2 months, is that never had, I think it was 11 years, the company still did not need to contribute more, even when the fund's reserve dipped low. So this was something that the union was concerned about in 2018 when the report came out that the funds had dipped, I think it was to 2.5 months. And the union said, let's talk about this. Let's talk about it in 2018 before the year that our collective bargaining agreement is going to expire. And so given that, and given that the company always had the ability to increase contributions, which it did twice during the bargaining in 2019, there was no compelling reason to immediately change plans, which they would need to establish. Again, it's their burden of proof under the economic exigency test. So on the substantial evidence in the case, which the judge and the board looked at, this is not a case where the company has carried its burden of being able to unilaterally implement its plan.
Ms. Beard, oh, sorry. 3 minutes. Can you turn to remedy now, please?
Absolutely. So Judge Walker, your questioning of my friend is something that I want to echo here with regard to what is before this court properly about the remedy. When the ALJ issued the remedy here, the remedy did not include any sort of set-off for what the plan would have saved had, for example, because the alternative plan went into effect. The remedy did not include that. Now, what my friend accepted to in its exceptions was the ALJ's remedy that included that set-off. What it did not do is argue, put in front of the board that restoring the fund and not allowing for any sort of offset was an abuse of discretion or was some sort of a windfall. They did not make that argument in front of the ALJ. Then what happened is the board issued its decision and did, as my friend stated, and conceded a different remedy. What the board did in its decision is say, you know what? There isn't going to be such a setup. We're going to give our standard remedy when there's a fund that employees still may have a legitimate interest in. And we are going to say you restore the viability of the fund, which goes to status quo ante relief. And that was when, if my opponent had an objection to such a set-off or a windfall argument, that is when under Section 10E of the National Labor Relations Act, this court's decision in Spectrum should have and needed to make an objection to the remedy that they're now making in their brief. Because they did not do that, they are foreclosed from making that argument.
I get that, and you might be right. But where our discussion led, and where I'd like to get some clarity from you, is there's a line in your brief, I think it says something along the lines of, Rite Aid is, and this may not be a direct quote, but Rite Aid is free to make their remedy argument at the compliance proceedings.
Sure. They are free to make traditional compliance arguments as to how much money they are owed. However, what the brief didn't say, and what we are not saying, is that in compliance, Rite Aid is free to argue that the fund would be getting that kind of a windfall. They cannot make that argument in compliance because the board's remedy, the standard remedy that the
They
board—
can't make their, is it Grondorf, am I pronouncing that?
Correct.
They can't make a Grondorf.
Correct. Well, depends what you mean by a Grondorf argument. The board's view is that in order to restore a fund to its undiminished viability, what needs to happen is the delinquent contributions to the fund have got to be restored, period. That's the board's holding, that's the board's view. Board did not engage with any sort of windfall, Grondorf, any of that, because it wasn't raised to them. But to the extent you would do what I would ask, which is enforce this order, there will be compliance proceedings. I believe in Grondorf, the court talked about remanding. You don't ever have to remand for compliance. Compliance happens after a board order on the merits, but in a compliance proceeding, there are various things an employer can do. I'm representing to this court, if this court enforces the order, I do not believe in compliance that the company will be able to come in and make an offset windfall argument for the fund. The board's remedy in this case is its standard
The
remedy.
union fund's still in existence,
I believe,
or did it dissolve?
I don't believe, I'm not 100% sure, Your Honor, because it's outside.
Suppose it dissolved. Suppose it's no longer in existence.
Well, if the fund is no longer.
You know, what I'm thinking about and what I'm focusing on, trying to focus on in this question is, you know, the employees. I mean, if the remedy is what you say it is, then on the day that we enforce that remedy, do all the employees revert back to the union plan?
Right. My understanding is that the plan is viable to the extent this court orders the board's remedy to take place, that the plan can be restored to what the board has ordered, which is to undiminished viability. But that's from, you know, the intervenor union, and my understanding, again, outside the record. But if there was, in compliance, Your Honor, my understanding is those kinds of arguments, like impossibility, for example, if my friend wanted to argue on the other side, it's impossible, there is no fund, we can't restore it. Do believe that is something that can be raised in compliance. I think that the only twist here with regard to compliance is this issue of whether they could bring specific evidence in that claims would have been paid by the alternate fund. And you know, one thing I also want to say about that is about should this court, which I don't think you should, reach the Grondorf issue. This case is not like that in Grondorf, there was, the statement that the court made in Randolph was that there were comparable healthcare benefits. They are not, it's not in dispute here. The healthcare benefits here do not include retirees. So retirees lost their healthcare in January 1st, 2020 when this went into effect. Doesn't include a platinum level plan. It only includes one lower plan, gold level plan.
Is there anything in the union plan that bars pre-existing conditions?
Your Honor, I'm not sure of the answer to that. I don't know. My friend on the other side might know the answer to that question. But what the board is trying to do here is restore the status quo ante under its clear standards. And I would urge the court to go ahead and enforce. Yes.
I just want to make sure I understand your point about the distinction between a Grondorf type argument and the argument that the company made in accepting to the ALJ's decision. So I'm just looking at, this is page 36 of the appendix, and it says, respondent accepts to the recommended remedy of making all contractually required contributions to the fund as unit employees have been covered by a substantially similar health plan since Rite Aid's implementation after impasse. Now, one reading of that is saying we need an offset here for the alternative benefit we've been providing. So I just want to make sure I understand what else should they have said?
Sure. I would say that given what they were accepting to, the remedy from front of the ALJ did provide for that offset. The exact remedy that exception, I think it was number 52, was responding to,
Yes.
was to the order, which what the judge had in the order was there will be such a set-off. So I myself do not understand what the exception was because that order had the set-off.
Not that the exception should have been different. If they had filed a motion for, otherwise put this in front of the board after the board amended the remedy, it could say exactly what this said.
It could also say there could possibly be a windfall or an offset, and the board would look at it and say, well, that's what the judge said, and we changed it so that there isn't one. So that's where the 10E and the jurisdictional bar comes in. The board needs to be on notice that what the company is objecting to is that.
Thank you.
If there are no further questions, I will sit down. Thank you.
Just 2 points, Your Honor. One, the issue of reserves and the scarcity of reserves was an issue that the union raised in 2018. They raised it in 2018 bargaining meetings. They raised it in 2019 bargaining meetings. They raised it in every single bargaining meeting up to December when they flipped and said, oh, we don't care about the reserve anymore. If that's not evidence of bad faith bargaining, I don't know what is. That's a flip. So the judge, and I didn't do much about my impasse argument, but there's plenary evidence in the record. Any experienced collective bargaining person would know that the union slow walked this all the way through those 18 months. They went months between meetings. They came to meetings with no proposals. They went golfing on a day that they said they would be there. They came in and threatened to strike when Rite Aid even suggested that its plan might help here. And then they did. They did protest, and they increased the protest. There's evidence of that in the record. They went on a campaign to get people to switch their prescriptions from Rite Aid to some other employer and appeared in pickets in front of the Rite Aid stores in Northern California. So that's evidence of impasse as well that was totally ignored by the judge. And to say, for example, that a proposal at the end was actually substantially breaking the impasse, Rite Aid just told the union it was an impasse in September when the union came to the table and threatened to strike.
I'm still a little confused about what you're saying and a little bit confused about what the government is saying with regard to remedy. Let me try one more time for clarity. I'll read to you what the government said, I think, in the brief. Rite Aid is free to make their remedy argument at compliance proceedings. You mentioned that you were looking for a concession. Is that the concession you're
No,
looking for?
actually, I got the opposite concession from my friend here. What she said was, no, you don't have the right to introduce that evidence.
That's how I heard it too.
Yeah, and
then-
so I don't,
Okay.
I just believe
And
that.
then
Go ahead.
I asked you earlier, are you challenging the alteration because the alteration leads to a windfall or not? Or are you challenging something beyond that? And you said just the alteration,
When you said the alteration,
the board's alteration to the ALJ's remedy.
yes, well, obviously, I'm challenging the board's alteration to the ALJ's remedy, but I'm also taking a position that the refusal, the trial in this case had no introduction of that evidence or that issue. And so Rite Aid did not have an opportunity to put that in front of the ALJ. And then when the board altered the remedy, obviously, we didn't have any chance to put any evidence
You're
on
only
that.
challenging the alteration by the board to the ALJ's remedy, then that's forfeited because you didn't move for reconsideration.
I don't believe under the cases I'm required to move for reconsideration. The cases we cited all say that we're not required to do that.
Okay.
So, I respectfully disagree with that. Thank you.
Thank you. That's- Case is submitted.
Case number 22-5267, Architects and Engineers for 9/11 Truth et al., appellants, Barbara Krukowski-Rastelli and William Privital, AIA, versus Gina Raimondo in her official capacity as Secretary of Commerce et al. Mr. Harrison for the appellants, Ms. Potty for the appellees.
Morning, Your Honors.
Good morning.
May it please the court, Nick Harrison for all the appellants. The appellants include one nonprofit organization, several family members of victims of the 9/11 tragedy, and several architects and engineers individually. Plaintiffs brought several claims under the Administrative Procedures Act for arbitrary and capricious agency action by the defendant agency, National Institute for Standards and Technology. The underlying controversy relates to a study of the collapse of World Trade Center Building 7 on 9/11, the day of the terrorist attacks. The district court dismissed all the plaintiff's claims for lack of standing, informational and organizational standing. And in doing so, district court misconstrued this court's precedent on both informational and organizational standing. The court, in particular, the district court, failed to adopt, as this court requires in its precedent, the plaintiff's view of the statute that requires disclosure of information that the plaintiff did not receive. And that controversy, in terms of what plaintiff's view is, we're talking about the National Construction Safety Team Act. We're talking about the requirement on NIST, the agency, to produce a report to the public that it identifies the likely cause of the building's collapse. the statute was designed to require studies of collapses of buildings where there's been a major loss of life or where there might be the potential for a major loss of life, as was the case with the Trade Center building collapses on 9/11. So plaintiff's view is pretty straightforward. Statute requires a report, not just a report. District courts seem to focus on just the requirement for any kind of report. But the statute says a report that identifies and analyzes the likely technical cause of collapse. So the information the plaintiffs were entitled to here that underlies their informational standing, not just a report or any kind of report. It's a report that gives an honest, good faith, meaningful identification and analysis of the likely cause of the building's collapse. And the complaint, which, as in the prior case, the allegations in the complaint need to be taken as true for the purpose of a motion to dismiss, which we have here, establishes that the agency's report was not done in good faith, was essentially a sham report. It did not identify the likely cause of the Building 7's collapse. That's where, the district court failed to honor your honor's precedent, this court's precedent, which requires the plaintiff's view of the statute to be taken as controlling for deciding the standing question.
I know we have to, as a general rule, take the allegations in the complaint as true, but what are the limits of that when it comes to your allegations about how to interpret a statute?
I don't know that there is a limitation.
What if we interpreted a random statute to give you access to the president's schedule every day ahead of time? No, sorry, not if we. What if a complaint interpreted a statute to do that? Is the court supposed to just take that as true?
No, sorry.
No, please.
That would be an extreme example, and I think most everybody would have trouble accepting that as a legitimate requirement for security reasons. But I believe that that type of problem gets addressed at a later stage in the case where there's an evidentiary hearing.
So you think we couldn't even reject that theory? We couldn't even reject that theory at a motion to dismiss stage?
It's a good question. I think if the plaintiff's theory is plausible, that may be the standard we're looking for here, then it has to be accepted for deciding the standing question on a motion to dismiss. Here, we certainly think it's plausible for citizens of this country to expect a federal agency mandated to issue a report involving the collapse of the building and a major tragedy to do so in good faith, not issue a sham report, but one that actually addresses the congressional intent, which is identifying the cause of the collapse. Congress is trying to achieve a public interest goal here. We're trying to get the agencies to help prevent future tragedies by identifying the correct cause of the building collapse. If that doesn't happen, those types of tragedies may reoccur, and the public interest goal is not achieved.
Did you, or not you, but did any of the plaintiffs make a request under 7306 for the release of information?
A good question.
Underlying the report?
It's a good question, Your Honor. I believe one or two of the engineers did. Mr. Brookman may be an example. He gave a declaration.
In his individual capacity, and he was granted some and denied others.
I think that's correct, Your Honor.
And he never sought judicial review of the denial, right?
Not other than through this case.
Not what?
Not other than through this particular action.
Well, he can't do it because the statute of limitations ran.
I might respectfully disagree with you, Your Honor. We did assert a fraudulent concealment argument on the statute of limitations question in the complaint.
Brookman's submitted a request in 2014, was denied in 2015. The statute of limitations for review of FOIA cases is 6 years.
That's correct, Your Honor.
So the statute is run.
Well, if there was fraudulent concealment, Your Honor may be correct on that particular point. I just want to preserve my position on the
So
fraudulent
the
concealment.
7306, which requires the release of information, this is the thing that I was focusing on here.
Yes, sir.
But it requires a request.
I think that's true. And our claims are mainly 7307.
District court said, well, you have to go through FOIA in order to do
District court
that.
did say that.
But I'm not sure that's correct.
I don't believe it is correct, Your Honor. The statute,
But
the
you at
national-
least have to make a request.
and I
We
think
would
that,
not entertain a case from a litigant who came in and said, listen, the Department of Justice has such and such information and they haven't released it.
understood.
We wouldn't entertain that because if the individual never requested the Department of Justice to release it. And that's the situation that it seems to me is where you are now.
Well, I don't think that's correct because the heart of the complaint is not about 7306, it's about 7307, and the requirement to issue a report identifying the likely cause. That requirement doesn't require a request. 7307 does not require a request. 7306 does.
That's
So
7307 is the report, right?
it is a report requirement to be issued to the public.
And you can challenge the report by asking for a correction, and you did that.
And we did
And you
do that.
lost.
That's why we're here, Your Honor. Yes. And we lost because of an arbitrary decision that,
I find it odd that you're challenging the rejection when you don't even put that, the rejection letter in the appendix.
the appeal denial letter, you may be correct, it may not be there, but that is, we are challenging the denial of a request for correction and the denial of the appeal on that denial of the request for correction. That is what this APA claim, set of claims is about. And, Your Honor, I wanted to make one big picture point. I'm using my rebuttal time, I see. And that is that in applying a standard that is overly restricted on citizen access to the courts, meaning standard standing to sue, there's an inevitable consequence of that narrowing of the standing doctrine, and that is that Your Honor's authority to do judicial oversight of the executive branch and to correct agency misconduct is likewise narrow. And as Your Honors know, unlike Congress, who can initiate congressional oversight on their own initiative, Your Honors can't do that.
I have one last question. What do you think was the harm that Congress was trying to prevent with the statute, and how was that suffered here?
The National Construction Safety Team Act statute, I assume is the one we're referring to, was intended to prevent future building collapses that cause major loss of life by having the federal agency identify the causes of the prior collapses, inform the public and the scientific community. I think there were two audiences targeted by Congress, Your Honor.
That harm just sounds quite different than the harm you think happened.
Well, we've got the harm that we articulate and that we assert is that for the group of architects and engineers whose profession is to construct buildings that don't collapse and kill people, protect the safety of their clients, that this statute was intended to serve that audience by helping provide correct analyses of why buildings collapse in major tragedies. It was also intended to serve a second audience, and that was the victims of the building collapses, to help them understand why their loved ones lost their lives. And so that's why we think both groups of our plaintiffs, appellants have standing here, and we're within the scope.
Very good.
Thank you, Judge.
Anything? I'll give you 1 minute on rebuttal.
Appreciate it.
Ms. Potty.
Good morning, Owners, and may it please the Court, Catherine Potty for the United States. A plaintiff has not suffered an informational injury unless it has been deprived of information that a statute requires the defendant to disclose. Plaintiffs here point to two statutes, the Information Quality Act and the National Construction Safety Team. Neither will suffice. Starting with the Information Quality Act, this court has already recognized that the statute creates no legal rights in any third parties and thus cannot be the source of plaintiff's claimed entitlement to the information. The court has also recognized that it does not constitute a statutory mechanism by which an agency's conclusions can be challenged. That's in the Mississippi Commission case, quoting Judge Ludig's opinion in Salt Institute. Turning to the National Construction Safety Team Act, plaintiffs have already acknowledged that NIST has submitted its report in 2008 on the analysis, including NIST's analysis of the likely technical cause of the collapse of World Trade Center 7. That is what the statute requires. That is what NIST provided. And plaintiffs have not plausibly alleged that they have been denied access to any information that they have a legal entitlement to.
Let me ask you two questions. The first is maybe try moving the microphone a little closer to you. I think we're going through this week with some growing pains on our new audio system. It's not you, it's us. And then the second is, imagine that the NIST had just never published a report. Who would have had standing to challenge that?
So I'm not sure if there would have been standing to challenge that. Though there could perhaps be a plaintiff who, one, plausibly alleged that there was no report, and two, offered and articulated an argument for why they have suffered the harm that Congress intended to prevent by requiring the disclosure. There are a million statutes requiring agencies to issue millions of different reports. That doesn't mean that there's always standing to challenge an agency's report or not. Here, plaintiffs have alleged that NIST issued the report. They do suggest that they offer allegations that it may be a sham, but the question is not whether whether plaintiffs disagree with NIST's report, whether they want a different report. It's whether NIST, the agency with the world's leading experts in structural engineering and analysis of building failures, has issued a report on the investigation as required by statute.
I just want to understand the first requirement, at least for informational standing, is that they're entitled, a statute entitles them to the information. And at least on that prong, if no report was issued at all, would you be contesting that they satisfy that step of the analysis?
Not the first step. Your Honor.
Okay, and so do you have a concrete conception of the second prong of who suffers the type of harm Congress sought to prevent in 7307?
Well, we have not focused on that prong here, Your Honor, because there is a report that does have this analysis, and so when plaintiffs failed at the first prong, that is where the analysis stops. Plaintiffs do allege in their complaint, for example, that some of the plaintiffs are family members of those lost on 9/11, and that if NIST revised its report in the way plaintiffs desire, then that would prompt investigations resulting, they speculate, in conclusions that explosives also set off, caused the collapse of World Trade Centers 1 and 2, the Twin Towers, and that would provide some closure. That chain of reasoning seems especially speculative, and I do not think it would satisfy the second prong, but they've not offered other theories about how that would work. I do want to point out, Your Honor, that the allegations themselves engage substantively with the analysis of the building's collapse here, undermining any suggestion that there is a lack of engagement or thorough analysis here that would be the equivalent of simply not issuing a report, which is really the question here when there are these allegations of a sham report. So, for example, in paragraph 126 of the complaint, they do identify the basic mechanism of the collapse as NIST explained it. It is that the heat from these fires caused beam A3004 to expand, and that this expansion caused girder A2001 to be pushed off of its support at column 79. And they quibble with that analysis. They say that beam A3004 could have only expanded 5.7 to 8 inches, and it would have needed to expand 6.25 inches. At this point, we are so far beyond any allegation that there was no report, no thorough engagement with the analysis. If there are no further questions, we ask this court to affirm.
Thank you.
In closing, the government is asking your honors to open a sort of a major gap in the ability of citizens to access courts to review agency misconduct, to create a substantial new limit on judicial review of agency misconduct. And it's, if you adopt the government's proposed rule, the agency will be in control of when they get judicial review and when they don't. Because Congress imposes a mandate on the agency to do like a report or an investigation, some major effort to protect the public, as here regarding the biggest tragedy arguably in our history, and they decide to do a sham report, basically disrespect the congressional intent for whatever reason, corrupt or otherwise. The rule that you're being asked to adopt is that's okay. Sham report is okay because the agency did what Congress asked, which was simply to issue a piece of paper, some words on it. I don't think Congress would see that as compliant with their mandates here. So I think I would just ask your honors to be very thoughtful in deciding how the standing doctrine evolves, if it does evolve. I think your prior decisions have been thoughtful, and make sure that we don't inadvertently preclude judicial oversight in our very important check and balances system in the Constitution.
Thank you. Thank you, Mr. Harrison.